Good day. I'm Professor Charles Rose. I'm the Director of the Center for Excellence in Advocacy at Stetson University College of Law. And I want to talk with you today about several different concepts within evidentiary law. And we're going to talk about these concepts through the lens of the federal rules of evidence. And the reason that we use the federal rules of evidence is because they're the structure that most of the modern evidentiary codes in the various states are built off of. Because they're the structure that came first, even though each state code has some fundamental differences with the federal code, except for California, which is, of course, always different, we have some degree of specificity that we can look to as we talk about our individual state codes. It's also important for most law students because the federal rules of evidence are the things that the multi-state bar examiners rely upon. It's the rubric that they use to test your basic fundamental knowledge. This is part of a series of lectures that are available to you. You can look at them on our online resources. They're also present and available as supplements or inserts to various electronic textbooks that I've published. Let's get started. What can I tell you about the federal rules of evidence in a nutshell that's important to you to know and to remember so that you understand it initially? The federal rules of evidence are rules of inclusion. Now, what do I mean by them being rules of inclusion? It means the idea at the outset is that all evidence at trial is admissible unless specifically excluded by a rule or policy that prevents it from being admitted. And so the federal rules of evidence, when they came into being as a code, completely flipped 180 degrees what the common law approach had been. Because in the common law approach, we thought evidence cannot be admitted unless there is a specific rule or procedure that allows for it to be admitted. And that is a completely different change. And so scholars often talk about evidence being, the Federal Evidence Code being a code that is inclusive. When you're thinking about evidentiary law and how it's used, you've got to look at the facts that are available to you, the moment where you are within the trial or the pretrial process, and then you've got to consider who is on the witness stand or how is the evidence being proffered. It's a sorting game. It's like the sorting game that you had when you were a young child. Remember when you had that toy, it was either a cube or a box, and you had the little pieces that you had to get inside the box. The pieces have a particular shape. Each hole has a particular shape. If you were able to line up the piece of the hole, you could push it through and get it inside. Think of the box as admitting evidence at trial. I've got these facts that come through a witness or some piece of evidence, and I want to get this fact into the mind of the jury, but I've got to push it through an evidentiary hole that makes it admissible. When you begin to think of evidence in those terms, you start to see how, when you combine that with your knowledge that the evidentiary rules are inclusive as opposed to exclusive, you can quickly develop a set of checklists, a set of procedures, a way of thinking about the subject holistically as you deal with it individually that allows you to master what is otherwise one of the most complex subjects that is taught in law school. Why is it complex? Because it connects many different elements of your law school experience. You have to understand the substantive law. You have to understand procedural law, criminal procedure, civil procedure. You have to understand issues of procedure within evidentiary law itself. And then if you step back, there are also constitutional implications when dealing with evidentiary law. In fact, the evidentiary common law before the passage of the code relied heavily upon constitutional analysis when determining whether or not evidence is potentially admissible. So if I know these things about the evidentiary code and I have them solidly in my head as I begin to think about it structurally, if I have them in the back of my mind as I look at each individual rule, what I find is that what seems not understandable to actually be a piece of the greater whole. And that is really the trick when it comes to understanding how evidence works. You learn the rules individually, but you must apply them in a connected fashion. And it's identifying where the connections exist that empower you to be better when it comes to working with evidentiary law. Now, we're going to talk about some of those in these presentations. We're going to look at the connection between character evidence under 404 and impeachment of witnesses under 608. We're going to look at how hearsay connects to the Confrontation Clause, the connection between hearsay and expert witnesses, and how the umbrella of logical and legal relevance sort of forms the giant tent under which all of these rules operate. Now, there are a couple rules that scurry out underneath the tent and get away from logical and legal relevancy, but there aren't many of them. And where they exist, I'll identify them for you so that you can understand the policy reasons that they're different. Let's get started.